Hello and welcome to today's RIMS webinar, sponsored by Prudent Insurance Brokers Private Limited, Digital Personal Protection Act of 2023, a fireside chat, decoding data fortification inside India's data protection law. My name is Justin Smollison, Business Content Manager here at RIMS, the Risk and Insurance Management Society. A few notes before we begin. If you have a question for the presenters during today's session, please submit them by writing in the question box. Feel free to ask at any point in the presentation. Our panelists will address as many as possible today, and they will also be gathered, and the Prudent team will reply to you directly. Following this session, the recording will be available through the on-demand events page of rims.org. And views of the panelists are personal in nature and do not necessarily reflect their respective organizations. IRDAI and does not underwrite the risk or act as an insurer. Insurance products are obligations only of the insurance company. Prudence team offers you a chance to compare the best insurance policies, services offered by various insurance companies, and then buy a plan. For more details on benefits, exclusions, limitations, terms, and conditions, please read the sales brochure or policy wording of the insurance company carefully before concluding a sale. RIMS is the Risk and Insurance Management Society. The society organizes education and training programs. The trade names or trademarks of the third parties are used solely for the joint event purpose only. Finally, all downloads and contact information will be accessible to the sponsor. And on with today's presentation. RIMS is thrilled to be joined by a large global audience. Our panelists have decades of experience between them and are here to explore developments surrounding India's new Digital Personal Data Protection Act of 2023. Please welcome our panelists. Mr. Yogesh Jinde is the head of risk management and data protection officer at WNS Global Services, and Mr. Sajay Singh is a partner at JSA Advocates and Solicitors. Please also welcome our moderator, Jyoti Krishnan, General Counsel and National Head of Liability Claims for Prudent. Jyoti, the virtual floor is yours.
Thank you, Justin. Welcome, everyone, and thank you for joining us. So today we are discussing the Digital Data Protection Act, the recently enacted law in India. Before we go into the view of the panelists on what the law is or what they feel about the law, it's important to maybe do a little deep dive into what the law talks about, or what are the broad gamuts that it aims to cover. Now, as the name suggests, the Act aims to provide for processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and also the need to process such personal data for lawful purposes. The central theme of the law is consent, which goes to show the emphasis on the right of data principals, that is, people whose personal data is being processed. A data principal has a right to give consent as well as withdraw consent. They can determine who will process their personal data, how, and for what purpose and duration. And in case they withdraw their consent, then both the data fiduciary and the processor are required to stop processing their data right away. The Act also creates separate roles and responsibilities on fiduciaries and processors. While a person who determines the purpose of processing is named as fiduciary, the person who actually carries out the processing, which is storing, analyzing, collecting, etc., those organizations and entities are called as processor. And there is a direct line of responsibility on the data fiduciary to ensure that the respective data processor abides by the provisions of the Act. The Act also talks about significant data fiduciary. Of course, what exactly that means and who all will be categorized as significant data fiduciary depends on the regulations once the parameters have been crystallized. But broadly speaking, the Act does throw a little bit of light on what are the broad aspects which will determine this concept. What the Act wants to focus on is the sensitivity of the data, the volume of the data, and the security of the state, integrity, and sovereignty. These are some of the parameters that we expect to see in the regulations once the regulations are crystallized. We've also seen several iterations and versions of the law being introduced into the parliament, which had lapsed. And this law has faced several reactions from different sectors across. While some people view this law to be a measure which enables protection of personal data, it improves data security infrastructure and also allows for a more compliant atmosphere, there are others who feel that it is going to increase the expenditure on companies to become compliant, which may result in businesses not being able to cope up. Now, ultimately, the significance will lie in the detail. While the Act talks about the what, it's the how which will tell us the impact of the law on various sectors, businesses, and organizations. The forthcoming rules and regulations need to ensure simplicity and ease of implementation and compliance. But ultimately, businesses must orient their employees to align data collection, storage, and processing with the Act stipulations. Ultimately, from an organizational perspective, what seems important and pivotal for adapting to the new law would be a combination of implementation of robust IT security infrastructure, along with creation of a procedure for data destruction, data security, and consent related compliances. Ultimately, all organizations will need to look at deployment of risk mitigation and transfer mechanisms to address breaches. Now, to know more as to how the new law reacts with the existing businesses and how companies can adapt and become compliant, we're speaking with distinguished panelists today. We'll hear from them firsthand, their view on the new law and its consequences. In today's chat, we'll aim to explore many new areas of the law, with the ultimate aim of keeping our audience better, get them a better understanding and appreciate the law. And to aid us with this, we have our distinguished experts with us. To begin with, we thought we should perhaps dive into the question that has been on everybody's mind. Since the time that Indian data protection law was first introduced into the parliament, it was always compared with its global or its European counterpart, the GDPR. So to start with, I would like to ask our panelists today, and we'll start with Yogesh, you, as to how do you see the Indian data protection law in light of the European GDPR? Would you say that there are resemblances between the two laws, or do you think the Indian law is creating a paradigm shift?
All right. Okay, that's an interesting question. Clearly, the GDPR set a sort of gold standard for privacy laws to follow. GDPR, despite common view, it wasn't really the first privacy law in place globally. There were laws that preceded that, HIPAA in the US for healthcare, PIPEDA. But I think what GDPR brought to the table was it formally enshrined certain core aspects of privacy. And when I say that, I mean things such as data minimization, data subjects right, consent as a mechanism. And laws that have followed, and that includes the Indian DPDPA as well, those borrowed, or rather they built upon what GDPR had actually enshrined or formalized for the first time in terms of a law of this nature. That being said, I think the DPDPA is far from a replica. No other law that has followed GDPR, in fact, is nearly a replica, but these core concepts are common. So to that extent, there is indeed a resemblance between even the Indian Act, the Indian Privacy Act, as well as what GDPR has. But there are clearly some differences, and some of them are, I think, they make life, if I may use the term liberally, easier for corporates to comply with, while some might well make them more difficult. Now, I think you touched upon some of them in your initial introduction to the Act itself, but I think the first most striking feature is that the Indian DPDPA, it covers primarily digital data, or rather not primarily, solely digital data. This is a big change from GDPR, where even offline data, as would normally term it, would get covered as well. The second is, and I think at a later point of time, perhaps this requires a more elaborate discussion, and we'll get to that. But consent is not only just the primary mechanism in the Indian DPDPA. I think for all practical intents and purpose, for most corporates, it is going to be the only mechanism. And I'll explain what I mean by that. While there are legitimate use concepts included in the Indian DPDPA, the use cases are very narrow when compared to GDPR. And so primarily, I see corporates relying on consent as the only mechanism whereby they can get or they're able to process data from data subjects. There are other differences as well, and as we speak further, I think we'll cover those. But the data subject rights, while both the acts confer certain rights, there are some differences. It's a narrower, smaller list that's there in the DPA. I think one other striking, I'll hand over to Sajay after that, but one other main difference I see is that in the definition of breach, or the way breach is looked at, as it stands now, the Indian DPDPA really does not define any thresholds for breach. And I think that has caused a certain amount of uncertainty. Does it mean that even minor breaches could actually have, or they could attract the maximum penalty possible? Practically speaking, I do not think so. And again, this is a topic which we should ideally cover as we go along. But broadly, those are the sort of differences that are there between the acts as I see them. Some of them make life easier, as I said, for the corporates. Some of them may prove a little more challenging compared to GDPR. Yeah, I'll take a pause here.
Thank you, Yogesh. Sajay, what about you? Where do you see Indian DPDPA versus GDPR?
So I have a slightly different take on it. Generally, all the laws, data protection laws of the world have been based on the 7 principles of data economy, or 7 principles of data protection, if you want to call it. So there are these 7 principles. First is lawful and fair use of personal information. There's a purpose limitation, which just means that you only use the data for which it was collected. Data minimization, as Yogesh mentioned. You collect only the data that is needed, nothing else. There's an accuracy expectation that you keep the data accurate and up to date. You don't let it get diluted or corrupted in any way. There is a storage limitation. You keep it up till the time you need it for the purpose you collected it, and not perpetually. There's a security expectation that there has to be a degree of care when you have somebody's personal data. You need to put reasonable security practices and procedures to prevent a breach from happening. And, obviously, if a breach happens, then there is a whole process prescribed. And there is an accountability expectation on the entity who decides to collect your data or process, and as we use the word here, process the data. Now, these 7 principles were the principles on which GDPR was based, on which most other laws of every country were based, including the Brazilian law, which does mirror the GDPR a lot, but again, it's based on these principles. Now, what the government has done is very sensible. Its previous draft, the Data Protection Bill, the previous one to this, relied a lot on GDPR and faced a huge amount of stakeholder resistance. A lot of inputs came from industry. All of those were taken in, and then the government, I think, very sensibly thought it through and realized that if we are basing everything on 7 principles, why do we have to mirror another law? Why can't we just state those principles? And those are the principles. Literally, if you read the DPDP, it's like a short story. You can read it on a flight, and there's no legalese there. It's so easy to read. Every time I meet someone, I tell them, forget it's a law, it's your spare time reading, and they read it, and actually it's so simple, and it's been written so well that it just covers these 7 principles. Obviously, the devil is in the detail, and the detail is missing. That'll come in the secondary legislation. But this particular statute uses those principles, uses a lot of the stakeholder responses that came previously, and has simplified everything. Now, as the Data Protection Board is established and they opine, as rules and regulations and secondary legislation come, we'll know more about what compliance is, or like Yogesh mentioned, if there is a threshold, what is that threshold for reporting? How does the reporting happen to the board, to every individual affected, which is, could be a long list of people. So we'll wait for that. But the 2 points I wanted to make was that this is a very principle-based law, not prescriptive like the GDPR, not complex like the GDPR. It's very easy to read, and hopefully it'll be very easy to implement as well as soon as we have more clarity with the rules and regulations. And the second thing, as I said, it's very industry friendly, because obviously the government took into consideration the industry inputs that they got in the previous version.
Thank you, Sajay. That was quite interesting, because we have the sort of a pro and a con when we compare it to GDPR as to where they they took the right things and where they left what need not be taken for the Indian context. So it looks like a good combination of everything that could have come about. So that's a good start. Moving on, and I think this is a question or a concept that has always sort of lingered around when we spoke of data or personal data, especially in the context of the law that has been seen in other countries and also the various previous versions of the law that we saw being introduced in our country. So when the law was being envisaged, the concept of data localization and data residency became talk of town. And that was particularly in light of the boom of digitization that happened in the last, say, 5 to 10 years. More so during COVID because everybody started working from home, remote access was given, servers were installed, and access was given to those servers so that people could work seamlessly. The whole business continuity was dependent on being able to do so. Now, in that construct, the new law, it recognizes cross-border data movement, hopes to regulate it, but does not actually restrict it. So, Sajay, and I would like to start with you here. What are your thoughts on whether data localization is likely to become part of the rules, which is the secondary legislation, or do you think that the Indian law has left it open or sort of untouched intentionally?
So I would say, I think as we are moving from GDPR to the DPDP, I would say one very clear distinction on cross-border data transfer and the whole adequacy requirement, which I guess we'll cover later, which India will hope to get from the EU based on our law. The way that the GDPR works is it works on the basis of whitelisting a country. So a country which is considered to have adequate data protection laws, GDPR personal data can move to those countries. Unfortunately, India hasn't yet got listed, and hopefully this law will be the first step to get the adequacy recognition. India has flipped it around and has, the DPDP requires you can transfer anywhere. You can transfer your data everywhere. As a data fiduciary, your responsibility will continue to remain of care and all the things that I just mentioned. However, you can transfer it anywhere in the world unless a country is blacklisted. So from whitelisting, we've gone to blacklisting. So the government has to blacklist a country. So cross-border data transfer, totally free, totally easy. This obviously begs the question of data localization and residency that you were talking about, which, if you recall, Jyoti, in the previous version was one of the hottest, the debated topics, whether it be on the media, in any forum that you went to, data localization, people were going crazy. And as a lawyer, most of my clients are American companies, large American companies, and a lot of European and countries and companies from other regions of the world. And for them as well, the number of questions that I was getting purely on data localization and what needs to be done, what doesn't, people had started preparing, was huge. And the investment required was huge. And, all of that was going on. And everyone gave feedback to the government. Now, the government has intentionally taken it out because it was there in the previous draft. I don't believe, Jyoti, it's going to come back in the secondary legislation because the principles are stated here. The legislation, the secondary legislation, the delegated legislation, the rules, regulations, notifications, guidance, all of that will really be getting into the details of what is mentioned here in a very 35,000 feet view. So I don't think they're going to change the law in that sense. Of course, we don't know what views of interpretation the Data Protection Board will take, but I doubt that's going to happen. Now, it is very important to recognize, and which the DPDP recognizes, that data localization, which is a concept under the personal data regime, is a hotly debated and a very, I would say, emotive issue for many people. However, data localization is a concept that exists in India in any case. Several regulators regulate or require data to be localized. Now, what's the difference between those and this? That is a type of data, not personal data. Personal data may happen to be a part of that data. That's different. but that is focused on a type of data. Now, let's start with the Reserve Bank. Payment transactions, data relating to payment transactions, they want to localize. They want that data to be kept in India. So any digital payment transactions, they would like to keep it in India. On the same token, the MCA also has a requirement where if you're keeping electronic records of your company, then you need to keep that in India. So in that sense, several regulators have some requirements for data localization. Now, each regulator has its own concept. It can go out, but you need to keep a copy here, or it can only stay here. So there are various aspects to that. There's no one data localization requirement across board or with regard to all kinds of data. What we are talking about is one kind of data, personal data, which is digital, of course, but it's personal. Now, you may say that there is, in the payment transaction, there may be some personal data. That's fine. So that incidentally already needs to be localized in India. And that recognition exists in the DPDP. And that's very important. So the government, while drafting this, realized that there are already restrictions that various regulators have deemed appropriate and are keeping data in India. Why should we insert it again with regard to personal data? Because if personal data, like payment information or something, is so important for the Reserve Bank, there is something that already exists. Why add a burden of compliance? So that's what my input will be. And I would say anyone listening to this, because we have a very large audience from the numbers that I'm seeing, I would just say that they must go back completely fearless on that aspect of data localization for personal data. Remember, some personal data may be a part of other data that a regulator already requires localization in India. And that already exists, so it's nothing new that's coming about.
Thank you, Sajay. And I think that was very interesting because it's important, while there may not be a restriction in the law today, or there may not be a restriction in law, in this law, there may be a restriction in a different law, just because a data can fall into different categories. So Yogesh, coming to you, how do you see this playing out? Do you expect this to become a part of any regulations? And what are your thoughts on how the government has omitted to get into data localization or residency principles?
So largely, I agree with what Sajay has said, and I think consciously a call has been taken to actually omit for the time being the data localization portion. Obviously, there's a lot of feedback, as Sajay said. We all participated in the feedback mechanism. It's good to see that actually the government has taken our views on board. This was, in fact, quite a sticky point for some time. But that's good that it's not there. But that being said, and I'm putting on the hat of a risk manager right now, the mechanism for data localization does exist. The Act provides for it, whether it will be done through a secondary legislation or through any rules that are promulgated by the Data Protection Board, that remains to be seen. I don't think the intent is there, but data localization, again, as Sajay rightly used the word, I think it's a very emotive aspect, and this is all tied into geopolitics and security and things like that. So it's not in the realms of impossibility. I have an advice more than anything else. I would say if you're designing your systems now, consider the possibility of data localization coming in at some point of time. It may never happen, but don't tie in your data or construct your infrastructure in a manner where it becomes extremely or excessively difficult to move around data. There are mechanisms to do that. Even if you're on the cloud, you can have cloud instances that are specific, geo-specific to India and things like that. So when you're designing systems now, legacy systems is something you can go back to, but at least newer system, keep that aspect in mind, because if and when such a requirement comes in, you don't want to be scurrying about trying to figure out how do you make your systems work, move data and things like that. So that's the only advice I would have. Again, I am a bit cynical because I said I'm putting on my risk manager hat, but I have to sort of crystal ball gaze what could happen in the future. But yes, largely I agree. I don't think there is an intent at this moment, but the mechanism exists. So we should be slightly wary. Yeah.
No, I think that is what risk management is all about. Trusting but verifying.
Obvious.
So no, but thank you so much. I think it was interesting to see how, as a lawyer, Sajay has certain views which are based on, how the law has been functioning in different countries, And then as a risk manager, you have views which are which are from the point of view of, okay, on the ground, this is what will need to be done. Thank you. Uh, Moving on, and I think we all said at some point in time that the only principle, or rather the largely the principle on which our law is based, is consent. So consent is at the heart of the entire new data protection framework. In fact, not just passive consent, it's an active, informed, and granular consent. And that is what is expected to be obtained by the data fiduciary from the principal. Now, what will be interesting to see is, and that's where I think, Yogesh, I would come to you first. How do you foresee this requirement impacting the ability to do business in India for companies which excessively deal with personal digital data?
All right. So again, you spoke of consent. I think the concept of consent is again not very different from what it is in other privacy laws across the globe. It's pretty much the same in terms of it has to be explicit, it has to be informed. There is slightly prescriptive content of what the content of the consent should be and things like that. So that's fine. I think and since again I'm going to go back to GDPR for a comparison over here, where I think we differ, and this, again, going back to what Sajay said earlier, the 7 generally accepted privacy principles, as you call them, one of the important ones is the grounds of processing. Under what grounds are you processing personal information? Now, there's a nuanced but very important difference between GDPR, in fact, other laws as well, and Indian DPDP over here, is the GDPR, for example, provides performance of a contract as a basis for lawful processing. This is actually quite useful, if I may use the term that way, for corporates, because if you're performing a service or providing goods to a data subject, as they are termed under the GDPR, and you require that personal data for provision of certain of that service or those goods, then you don't really need an explicit consent per se. Okay, you can do it as a part of the contract. You can give a privacy notice and go on. Now, in case of DPDP, this varies slightly. There is a concept of legitimate use, but it's an exhaustive list that's contained, as I see it, within legitimate use. And performance of a contract specifically is not one of them. There is performance of an employment contract, which will go a long way actually helping corporates. That means that you don't need consent from your employees, because obviously as a part of employment, you'll be collecting a lot of personal data from them. So that's really useful from a corporate perspective. But performance of contract is specifically not explicitly there as a part of the Indian DPDP. What that really means, and going back to what you said earlier, is that consent, therefore, I think will be the primary mechanism to actually legitimately use personal data from your customers, from anybody who you're collecting personal data from. So that's a significant difference. You use the word, if I remember correctly, excessively collecting data or dealing with data. So no Privacy Act will allow excessive collection or usage of data, neither does the Indian DPDP. So I think it's very clear, again, going back to one of the principles that Sajay mentioned, data minimization, data retention, those apply to the Indian DPDP as well. Clearly, you as a corporate should not be excessively collecting data, should not be retaining data beyond the time where you no longer need the data. And things like that. Now, these may be a little bitter pill to swallow, I may say, for corporates, because who are used to collecting data and then later on, let's see what we can do with this. There is that mindset, right? We've all been through that, saying that you can go to a customer, onboard a customer only once, so let's get all the data you can from them, and later on, let's see what we can analyze and things like that. And especially with things with AI and profiling coming on, that it's very tempting to collect as much data as possible. On one hand, AI, since I touched upon the topic, thrives on data maximization, whereas privacy acts will look for data minimization, right? So, but it's very clear. Data minimization is at the core of all privacy acts, including this one. You should collect data only to the extent required, retain it only to the extent required, be explicit when you actually obtain a consent from a data principal, which is a data subject under the GDPR, on what data you're collecting, what is the purpose for collection, and so on and so forth, and the set of rights that need to be given. So I think, again, my personal view, since the Act, and as the preamble rightly says, it's actually more geared towards data subjects and not so much to pacify corporates. I think it's a good step. I don't particularly, even as a corporate, don't really mind it compared to GDPR. It will be a little more, from a purely implementation perspective, I think a little more onerous compared to the GDPR, this aspect. But I think in the long run, it's beneficial to both the data subjects as well as the corporates. Yeah.
Thank you, Yogesh. Moving to you, Sajay, what are your views on how the concept of consent and the granular and the clear consent that is required in the law, how do you see that playing out, especially for companies dealing with data, personal data?
Sure. So there are four concepts that I'll talk about. Of course, consent has already been spoken about. It has to be the granularity you both have spoken about. And the other important thing that I would just add to that is that it cannot be perpetual or irrevocable. So that's with regard to consent. But the three other concepts which are very important with regard to consent that I will mention. There's a whole concept of post-mortem privacy. But what that really means is that you can withdraw consent. And once you withdraw consent, obviously there are consequences. The consequences are, and what the Act is really good and the way it's written and what I was saying in the beginning is that it dumbs it down to a point that it gives you an example for everything that's written there. So it's very easy to read. So it's, like the particular, example here is that somebody gave their consent on an e-commerce website and withdraws it. So what the whole concept of post-mortem consent is that, you can withdraw it at any point. It's not that once you've given your consent, you are stuck to it forever. The third point that I will talk about is the non-consensual grounds for processing. And these, I think, are very important. And you had mentioned COVID, Jyoti. I think COVID has played a very important part in this section being drafted. These, of course, as would be expected, these are circumstantial. And these could be for medical treatment, health services, disaster assistance, a legal obligation. Interestingly, I do believe, Yogesh, that a contractual obligation will also get covered here. And, in theory, if a consent could be structured in a manner that it has been obtained as a part of a relationship, contractual obligation, it would be covered. But we can discuss that offline. Public interest, emergency response, or, performing a function under the law. So all of these areas would get covered in non-consensual processing of personal data. The final point, the fourth point that I want to make, which is a very interesting point, and probably, and again, I've worked with different countries and clients from all over the world, and what they also, and I've been having discussions with groups in different parts of the world. And this concept has been fascinating to everyone, to call it anything else, is the concept of a consent manager. Who is this person? Because I could engage a consent manager, whether it's a platform or a person, I don't know. The person has to be registered with the board, data protection board, and I can just engage him, and he or she or the platform or it or AI, whatever, will take care of consent for me. So that whole mechanism and that whole construct is very interesting that we have here. One of the very important points that I think is relevant here is that many people, because I really don't think Indians view personal data with the same passion as maybe people in the developed nations. We are a more communal society. We are not an individual society who's focused on themselves. And therefore, it's easier for us to share data with different people. And, the kind of questions we ask somebody when we meet them the first time is a clear indication that we don't really care much about personal data. So keeping that in mind, it's very easy for someone to share something which is very private. And therefore, the concept of a consent manager is very important. We'll have to wait to know more. But I just thought I should mention, to give the audience a complete perspective on consent, these additional points that exist. Yes, Yogesh mentioned the concept of consent in an employment context, very important. Till now, we believed, because it wasn't clear, we believed that an employee who shares personal data with the employer also has to give consent to the employer for collecting their personal data and for the employer to process it. That exception has been made in the new law for the employment context, or to protect the employer, or for compliance with law, preventing an offense. That's very good, because it's clear, at least, that you don't have to engage in that additional activity. But interestingly, at least the concept has come, even though you may say it's restrictive, personal data shared in an M&A context. That's very important, because there's so much M&A happening. And yes, that M&A has to have some court sanction, but at least that concept has been recognized. Again, for research purposes, for something where you are not taking a decision for the data subject, you have exceptions. So all these statistical and archival purposes, all these provisions actually make it easier for many services to be performed, and you're not getting too bogged down by compliances when there's an emergency or there's a situation which has nothing to do with the data subject. It's a very different activity for which some personal data is moving. That clarity, of course, clarity will come as we discuss later, but those concepts having been covered, I think it's a very welcome change.
Thank you, Sajay. Thank you so much. Now, you spoke about, the rights of the data principle, and how when things may not be necessarily about a person, it's in a larger context, and therefore there are certain exceptions to say so. And, those are good. What I definitely want to delve into next would be, so a data principle, I think we all know that because their consent has become paramount now, their rights have been well recognized. Conversely, as they say, when there is a right, there is a duty. Now, there are two sets of people or organizations who have been recognized in the Act from the point of view of complying with the provisions of the Act, and more so for data fiduciary, slightly less for a processor. And I want to basically delve into how do you see that, how will a data fiduciary be able to comply with the provisions of the Act and ensure that their processors also comply with the provisions of the Act? There's an overarching responsibility of one, doing it yourself, and procuring and ensuring that your processor does it. How do you see, Sajay, this responsibility playing through for people who are in the fiduciary category?
So I think very important point you raised and you touched upon is that no right can come without obligation. And when my first time I read the DPDP, I was actually delighted with the whole thing. Like we have, in our constitution, we have fundamental rights, but we also have directive principles of state policy, and everything, there's a balance. And unlike every other privacy law where all the rights are with what we call data principles or they call data subjects, and all the obligations on what they call data collector and we call data fiduciary, here that's not the situation. Even the data principle has obligations. And if they don't meet those obligations, they could be penalized. So I think that's a very welcome change. I do want to mention that before I answer your question. However, as would be with any data protection law, the person deciding on what to do with the data, the person who is processing your data, so the processing begins, say, with collection, is the data fiduciary. And all the obligations, that's the final, the buck stops there. So they have all the responsibility for compliance. But they can't do all the processing, so they do have to engage with a processor. That's being recognized in the statute. There are three concepts that a data fiduciary, and those data fiduciaries on the call may try, and who are engaging the data processors may like to verify the data protection agreements with. There are three concepts that you must make sure your data processor is taking care of. The first is the care. You have a duty of care of the data. So whatever the reasonable security practices and procedures, they need to give that same level of care, maybe more. There is an obligation to report to the board if there was a breach. And the breach requires a reporting to the board as well as each data subject or each data data principal affected. So that obligation should also be covered in the data processing agreement, because the obligation is on the data processor as well, because there may be a time lag and the board would like to know it as soon as possible. We don't know the timelines, but as soon as possible. And finally, if there's a cross-border transfer of data with the data processor, that's something that you need to be aware of. Again, it's totally free, but should there be any blacklisting of countries, then that has to be complied with. However, having said all of this, this is a back-to-back protection, but having said all of this, the final buck will stop on the data fiduciary. They are responsible vis-a-vis the board, vis-a-vis anybody else. And therefore, it's important that the data fiduciary takes its role, considers its role carefully, and where it can, where it's sharing data with somebody else, a processor, any other party, they must take care that the data processing agreement and all documents like that are carefully drafted. If they haven't drafted, I've seen so many situations where there's no real agreement for processing of data. They didn't even realize that there was a data processing agreement that needed to be signed. So please make sure you have, at every stage, the personal data is changing hands, an agreement to cover that situation. And thereafter, in that agreement, pass on whatever obligations you can pass on, especially the duty of care, which I think is the most important. Reporting and all is definitely there. Please cover that carefully in the document. So that would be my input on the rights and obligations. Of course, in terms of the obligations of the data fiduciary, it's a long list and we can go through that, but I think you wanted some broad input. So that's what I would say.
Thanks, Ajay. Thanks. Moving to Yogesh on the same point, how do you, so as we discussed, right, that there's an overarching obligation on the fiduciary to make sure that the processor also complies. Now, as someone who's working with a company, how do you think this is going to pan out, especially because we are going to have organizations sitting as processors and as fiduciaries?
Right. So again, I will focus on the implementation aspect of this over here. For a large part of my organization, in fact, we work as data processors under various privacy laws. And as Ajay said, the primary way to enforce obligations is through contracting mechanisms, the master services agreement itself, along with the data protection agreement and things like that. Now, again, from an implementation perspective, the tricky part occurs when how do you ensure that the data processor to whom you have further outsourced your processes and therefore the data that goes along with, how do you make sure that they are actually compliant with the obligations that you have put through the contract? That tends to be a more trickier issue. That I think the contracting clauses and all are pretty much well settled now. We've had the benefit of GDPR and similar laws, so I think that should be easy enough. Now, I'll step back a little. Vendor risk management, and I think, Jyoti, you touched upon COVID-19 related continuity aspects as well. Vendor risk management has actually been at the forefront of risk management in recent times, especially on account of COVID-19. We spoke about continuity, security, privacy is just another aspect that needs to be, if I may use a term, tacked on when it comes to managing the risks relating to vendors. Now, how that can be done depends upon the nature of the vendor, the nature of the data that the vendor will be handling, and the levels of risks that are associated with them. There are tools, of course, that help you manage information that you handed over to the data processor. The contractual mechanism, you can stipulate rights to audit, rights to monitor, and things like that, which absolutely should be there whether you actually go and audit or not. The challenge is that you may end up having, in some cases, perhaps hundreds of vendors as data processors. It may be small bits of information going to multiple vendors. It becomes extremely challenging, especially as the organization grows larger and your list of data processors keeps on growing, to actually be able to monitor these vendors, make sure that the obligations that you have passed on to them are actually being, I mean, you can ask for a self-assessment. That's one way a lot of companies do it. You can ask for a sort of certification that say that you adhere to it, but it's no replacement for an audit. There are other mechanisms as well. For example, in the InfoSec world, we have something called the SOC 1, SOC 2 reports, which has a privacy component as well. You can ask companies such as your data processors to actually provide a SOC 2 certification or SOC 2 audit report that has the privacy related control statements. It's a report essentially that the data processors will get their organization audited and provide that same report to multiple data fiduciaries or data controllers who ask for them. That's one mechanism that's commonly used. So yeah, it is a challenging aspect. Clearly, just because you have outsourced process downwards to a data processor, you cannot get away from the obligations either as a fiduciary or as an upstream data processor. So that's clearly not the case. Yeah.
Jyoti, I would just like to point out over here, because Yogesh's comment on the multiple vendors is very relevant to, we've got so many questions from the audience. The first question, if you were to ask Yogesh, because it probably will link into his answer that he just gave. So if you were to just read the first,
Yeah, I was in fact going to do that. So, so one of the questions that, and somehow they just timed it exactly when Yogesh was talking about multiple vendors and ability to manage where your data goes, how it goes. So one of the questions actually that has come up is, the concept of data fiduciary in India is the same as data controller under GDPR. Now, having that background, what they want to know is enterprises which have contractors and vendors employees, who will own the data fiduciary obligation. Will it be the enterprise who has the contract with the vendor, or the vendor who's employing those people? So it's basically like a vendor, and then there is a subcontracting for the employee. Who will be the fiduciary, and how will that work out is actually one of the questions that they've asked.
Okay, my view over here is that you have to go back to the definition of if it's GDPR data controller or if it's the DPDP data fiduciary. Basically, and I'm just paraphrasing this, the organization that controls what data is being collected for what purpose and what is to be done with the data is traditionally the data controller or the data fiduciary. In case of the specific situation that you have asked for, if it's the organization which is employing this contractor asking for data of the people who are going to be on site and providing personal information, it could be health information as well and all, I would think that such an organization would at the very least be a joint controller in the GDPR and perhaps a data fiduciary in the DPDP as well. I would say in terms of the consent itself, because and that's how we deal with it. We take a very conservative approach to this. If you are going to have people who are going to be attending your site, they are going to be providing information which is to be asked for, retained by you. We are the ones who actually get the consent from those employees. Parallelly, now that there's an Indian DPDP Act as well, when the original subcontractor is actually hiring those employees, they will also, and they will have perhaps a lot more data on the employees than even we ask for as a contractor, or rather someone employing a subcontractor. They will also need to obtain consent at the time of onboarding and for whatever purposes they want to use the data. So I would sort of at this moment lean on the side of getting consent from those people for the people who are working on the site as subcontractor, if you're actually collecting and processing data for them.
No, fair point.
Sajay agrees. I would love to hear Sajay's opinion on this as well. It's a bit area.
So what the law as it's written is that any person who alone or in conjunction with other persons, the joint controller that Yogesh had mentioned, determines the purpose and means of processing personal data as a data fiduciary. So the law recognizes that it's not one person, it could be multiple people. But if you alone or together with someone else have the obligation, you would, since we don't have as of now a joint controller, each one of those people could fall within the definition. Each one of those people will have an obligation. So you need to determine the use of that data, the personal data. So it's the purpose and means of processing is what's written over there. So if you are determining that this is the purpose for which the data is being collected, and this is how it will be processed, then you become what is called a fiduciary. You could be acting by yourself, or you could be acting with other people. So it doesn't matter, and there is no escape of liability that it was this person or that person who did it. So in theory, though it's not written there, I'm just throwing it out there. There could be joint or several liability if there is any ambiguity that is there one or two or three data fiduciaries in the picture. On that point, I will quickly answer the next question as well before you go to your question, Jyoti, because it's an easy answer. Yes, the question is basically that will prospective employees' personal data get covered in employment purposes? Lots of clients are asking us this question. I'm giving an extremely conservative view. I say when you are engaging with prospective employees, because obviously there are many people that you're engaging with, please get their consent, because we don't know whether that gets covered in what is called employment purpose. However, if you haven't got that consent, I think it's a good defense. If ever you were asked a question that you collected somebody's personal data and you didn't give it the care it should have been given, your defense will be employment purposes. But as of now, my advice to everyone is that if the person is not your employee, then it may be a good idea to get their consent if you are going to be collecting personal data. So please get their consent. Yes, once he's your employee, then things change. However, if you are not doing that, and if you don't want to do that, once again, it is a good defense. So just thought I'll quickly answer that question. Back to you, Jyoti.
No, thank you. Thank you for actually doing that, because it was also very topical in the scheme of what we are talking about right now. But coming back to, so Yogesh was talking about, how companies can look at vendor risk management, how that aspect of who's processing the data on your behalf can be taken care of, what measures can be established, and how you can ensure that you might be a fiduciary and you might be responsible for someone else's processing. What are the various ways in which the contractual obligation can be implemented? So taking the same line of thought and making it more specific, now you are also a DPO by designation. So how do you see this playing out between the various functions in the company? So, we have various risk functions. They are named differently in different companies. But where do you think this aspect of risk management is likely to be sitting? Who, amongst the CXOs would need to look at managing the processing of data on behalf of the fiduciary? So as a fiduciary company, who do you think is likely to be taking up the responsibility of making sure that the compliance is there and all the necessary processes are in place? Contractual articulation is taken care of, but at the same time, that articulation is then translated into an implemented process.
Right. Okay, that was quite a mouthful, to be honest. Okay, let me take a stab at it. See, the compliance aspects, regulatory compliance, not just a privacy law. It will always lie with the executive management with oversight of the board. Increasingly, it's gone upwards to the board, right? And not just in India, across the globe. So accountability, if I may term it that way, will always be there with the board and then down to the executive management. And then you can have separate functions you can make responsible for an implementation or a standardized implementation across the company. Now, coming to this specific law, and again, I'm going to base this on my experience with privacy law implementations for other countries as well. It's a shared responsibility in the end to actually comply with the law. I mean, this transcends it goes across the entire organization. The approach that we have taken, because there has to be some method to the, if I may call it madness, it's not madness, but method to the whole implementation, is we have actually made it a joint responsibility for implementation between the General Counsel's office, which is a legal function, and the risk management function. And the way we have segregated it is the framework itself, the design of the framework. And when I say framework, in fact, our framework, I'll just step back a little and say our framework, in fact, based on the 7 principles of privacy that Sajay spoke of earlier. And the reason for that is you'll have many such privacy laws coming along across the globe. And it has to fit into a framework which accommodates all these different laws. You can't have a separate program running every time a country. And especially for organizations like ours, where we have clientele across the globe, where we have processors, you have operations in most of the globe, where you have controllers, it becomes exceedingly difficult to have separate implementations for each law. But by design, these laws, as Sajay said, are actually based on these generally accepted privacy principles. And that's how we have built up the framework. So the design of this framework is actually, in my organization at least, a joint responsibility between the management function and the legal function, and it works very harmoniously. For example, from the risk management perspective, since traditionally information security forms a part of risk management, what we have done is extended our information security programs to incorporate privacy as well. What that really means in practice is that we always did risk assessments at a very detailed level for information security purposes to find out information security risk, right? At the same time, and the sort of stuff that you need to do is somewhat similar to what you need to identify in a privacy risk assessment as well. So the identification of what data you hold, what risks it faces, data flows, and things like that are actually jointly done as a part of the security exercise, which is now an information security and data privacy exercise. And there are more details to that, but broadly, that's a construct. From a legal perspective, the whole contracting chain, whether it's from the data controller or fiduciary to us as a data processor, to somebody downstream as a downstream data processor, the standard contractual clauses between different entities, between the different entities in the UK, for example, and India, or UK and Philippines, and things like that. So those are all the aspects that the legal team looks at. So it comes together, the legal contractual aspects and the implementation aspects that I spoke of earlier. Then you have the implementation functions. This could be the HR function. This could be the IT function, IT in the sense those who provide infrastructure where the data might actually be stored. There might be IT development groups who make these applications which processes data. And that's a very important function. We haven't really touched upon that, but these data subject rights that we spoke about, making sure your applications actually are able to honor those data subject rights is quite an uphill task. If somebody has not been through that for GDPR or for any other laws and are starting now for the Indian DPDP, I think there's quite a hurdle for them to cross. It's not impossible, but it can be a bit challenging depending on how far your legacy systems go. Then you have the other functions such as corporate communication. Anybody who's essentially collecting data from any individuals for any nature. So those are the implementation function, and tying all that in together, typically you have an audit function to make sure that the framework has been designed correctly, the implementing functions have implemented it correctly procedurally, and it's basically the whole framework's operating effectively. You could have internal auditors, you could have external auditors, you could have the sort of auditors I spoke about earlier who give you an audit report or a certification based on certain common controls and things like that. There are different ways to do specific aspects of the implementation. But yeah, it is pretty much an organization-wide affair, but the roles that different teams play are very different. I don't think everybody should be designing something for their own function. That's not going to work. You have to have an overarching policy framework. The procedural, the implementation aspects need to be done by a particular group, and making sure everybody's honest has to be done by the audit group. And accountability, as I said, will always be the executive management and the board.
Thank you, Yogesh. Sajay, what are your thoughts on this? And, coming as an advisor, because that's usually the hat that you wear.
So I think because we're running short of time, I'll combine this question with with the next question that you had set for me, because your next question was on preparedness for the coming law for companies. So I have some tips for companies to consider. I think these are very important, and like Yogesh said, in terms of deciding who is responsible, which tools to use, what to look at. For that, to establish those structures and standard operating procedures, I would give some tips to companies to look at. First, We don't now have the concept of sensitive personal data and personal data. All personal data is personal data. All personal data requires consent for processing. So opt out, let's forget about. Opt in is the consent that we need. So do your data mapping exercise, figure out where you have opt out and focus on opt in. Then now we have the new law gives a lot of rights to data fiduciaries, data principals. Do you have a mechanism for an easy communication between a data principal and a data fiduciary? Do you have that? If you have it, great. If you don't, map that. Create that structure, create that flow of communication. If that happens, then one of the communications that's very important is called a grievance. If there is a grievance, the grievance has to be addressed. There has to be a grievance redressal process. Do you have that? Who's responsible for that? Get that structure in place, because that is very, very key. And by the way, all these rights continue to remain even with employees. So, by just saying that the law doesn't apply to employees is not really that correct. It doesn't apply vis-a-vis, say, a notice, consent in the typical way it applies to other data principles. But the duty of care, the right to correct your information, to access your information, to amend it, all of those and many other rights that are prescribed under the DPDP exist even for employees. So please get the grievance redressal process in shape. Now, one very important data principle right is the right for erasure, or the right of erasure of personal data. And what you need to figure out is, if you ever question many, many years later that did you erase that data because you got a request, you'll have to prove that you did it. So it's a good idea to start checking tools that allow you to erase that specific data or all of that data, because we also have a question on data getting combined with other data. So I'm just taking that as well. So there are tools, and Yogesh can help you, and people can advise you on how to get the best tool that's suited for your company. Because get those in place, even though we don't have all the details, but at least checking out tools for erasure are very important to start considering. Then a health check of, do you process any children's data? Do you process any data of people with disabilities? Now, these people are special categories of people who have special rights. And there is a verifiable parental consent concept that exists for people, children under 18 and people with disabilities. So what is that verifiable parental consent? Again, details will come, but there may be tools that can help you with that. So it's a good idea to start checking those tools. Then, like Yogesh said, audits. Even though you today may not be a significant data fiduciary and the obligation on an audit or an impact assessment may not be on you, but why don't you just get good auditors to keep them ready if you need them at some point? So just start scouting for them as well. We will have a pretty detailed or a very important concept of data breach notification. So get that system in place. Start thinking what would be the standard operating procedure. How will you, when you get to know what are the steps that you go through, get that organized. In terms of your data processing agreements, it's a good idea to check if you have them. Wherever, as we discussed many times on the call, wherever data is moving hands, there should be a contract. The contract should be very clear, and all the provisions that you are obliged should, find their way into the contract to the extent you can. Of course, you can't have everything in every contract. And finally, which is causing, again, I keep bringing back our clients and their sort of issues and things, is the translation into 22 Indian languages beyond English. So be it any data principle facing document, you need to have the ability Of course, it's based on a request coming to your way, but you need to have the ability to translate that document in the local language and communicate with them in the local language. So do you have that ability? Why don't you try and find out vendors who can translate and get the exact accurate document in place? So these are some tips I thought I will leave everyone with, because I think we've run out of time, but over to you, Jyoti.
No, thank you, Sajay. In fact, I'm going to just, direct one last sort of question, combining what you said to Yogesh, and then we will look at sort of, wrapping it up. So, Yogesh, I think what we would like to hear from you is anything else you feel from a preparedness point of view that companies need to be thinking about, and also just a little, maybe a quick view on keeping the preparedness in mind. What challenges do you foresee companies facing when trying to prepare themselves for the new law?
Yeah, so I'll try to be quick about this. I think one of the central tenets of any privacy implementation is what we tend to call privacy by design. And I would like companies not to just pay lip service to that. When you're implementing a new process, when you're implementing a new system, a new piece of infrastructure, keep privacy in mind. Do not make it an afterthought. You do not want to play whack-a-mole with privacy issues later on. You do not want to try to retrofit your systems. In many cases, that's impossible to do. Now, when a new privacy law comes in, there is a certain amount of legacy systems and processes that need to be brought up to speed or brought up to meet the privacy requirement. That's done. But going forward, I think privacy by design has to be a central concept while designing any of these infrastructure, processes, systems, and things like that. This can, as I said earlier, could be challenging, especially when it comes to, and Sajay rightly touched upon that, all these data subject rights that need to be honored, including especially the one relating to erasure or even the ones relating to correction. Depending on the systems and processes that you have in place, you may need to do significant rework over there. So clearly, I see that as a challenge. One more thing, and it's relatively minor, but what I have seen based on privacy law implementations across the globe, whenever a new law comes in place, there is a surge of data subject requests that happens in the earlier part of the implementation. So clearly, as Sajay correctly pointed out, you have to have your processes and infrastructure in place to be able to handle a whole barrage of these requests coming in. To be honest, in our experience, these tend to taper down over a period of time, get more, if I may call them, realistic, but initially there will be a flood of requests that come in. Some of them may not even be, you may not have to honor simply because of the fact that other laws require you to still retain the data and things like that. Nevertheless, each request has to be treated with utmost seriousness because the levels of escalation that are built in, even in the Indian DPDP, you don't want a complaint against you. The third is, and I mentioned this word earlier, fear, uncertainty, doubt. I think there's a lot of trepidation initially regarding how certain things in the act will work. As Sajay again rightly said, I think this act is as practical and simple as possible. There is very little ambiguity as I see it, especially from, and I'm again speaking from an implementer's perspective. I think it's a very nicely put through act with lots of examples. So as far as possible, I think the government has tried to remove ambiguity. So it should be relatively straightforward to implement, especially if you have done implementation of any privacy law. Nevertheless, I think certain things will become more clear as there are more guidelines that come in. Perhaps at some point, some case laws will come in. You don't want to be the first case law. So I think most organizations will take the conservative approach. But that being said, I don't think it is too challenging to comply with, as long as the principles are kept in mind and in spirit the law is actually implemented for your organization, complied with.
Thank you, Yogesh. I like the idea that unlike charity, case law doesn't begin at home. So that's a good point. So I do have a bonus question. So we had a very direct legal sort of a question coming in. So Sajay, if you can spend just a minute in answering this. So if two sets of, if this data flow from country A to country B and two different set of data protection laws were to come into play, how do you see that playing out? And is there any kind of a mediation or a cross-border settlement available in the law, or is it going to be, let's see, wait, watch?
So there is the question is really asking if there is an arbitration agreement or a global body that can adjudicate on something like this. There isn't any. There are several multilateral organizations, including the UN and various other organizations, that are working on trying to see how standards can be met, standards can be created. Now, there's a lot of focus on AI, and we moved away from data protection. We are still where many other countries were in 2018 and all. So they moved further ahead. Crypto, AI, these are areas that several countries, including the EU, is trying to regulate. So, and then, there'll be other concepts of the metaverse that people will need to regulate, but there isn't anybody that can adjudicate. If the data belongs to a particular country, if it's Indian personal data, unfortunately, you have to comply with Indian laws. If it's EU data, you have to comply with EU laws. If both the data, gets mixed in a manner that you can't segregate, you have to apply both laws. And it will be a challenge because some bits, as we've discussed, is more, some bits of the law are more prescriptive on the EU side or GDPR side, less on the Indian side. So you'll have to be extra careful with that data when it gets so mixed up that you can't segregate the data. But closing with your, the point on penalties as well, which you had in terms of, since you're talking about how decisions are made, the penalties as well are very different in different countries. But I would close by saying that with regard to the Indian law, the DPDP, I don't think penalties should be of that much concern, because India as a country is not a country that awards very high penalties. And the law itself has given guidance of how the board is going to come up with a penalty. It requires the board or any adjudicating authority, that takes a decision on the penalties under the DPDP, going all the way up to the Supreme Court, will need to look at the nature, the gravity, and the duration of the non-compliance, the type of data that was affected, the repetitive nature of the non-compliance, whether somebody gained or avoided a loss because of the non-compliance, whether a person did things to mitigate the breach, its timeliness, its effectiveness, and is the penalty proportionate and effective to the non-compliance. And of course, if the penalty is imposed, will it be a deterrent for future non-compliances? So all of this has been prescribed, which in any other law, the board or the authority actually uses these principles, but they are prescribed, they're enshrined in our law. And I think that is very, very heartening. And all the industry folks on this call should go away feeling that there won't be abuse of the system. There will be rule of law. We kind of use this very loosely, but there will be protection, and the penalties, I don't think, whenever they are imposed or levied, will be very rational. So just wanted to end with that.
Absolutely. Point taken. Now, I'm just going to ask Yogesh if you have anything to add on the penalty aspect, particularly given that you coming from a company side and not necessarily an advisor side.
Yeah, no, I think Sajay has put it across quite eloquently, and I'm quite heartened to hear that we shouldn't worry too much about penalties, to be honest. But he's right, so even when GDPR came in place, again, there was a lot of rumor mongering, scaremongering that the smallest of breaches will have tracked the entire 4% of turnover penalties and things like that. I think that's the mindset that a lot of people, just by a cursory reading of the act, have come to that conclusion. But practically speaking, that's not really the case. It's not that the EU Commission doesn't want to award penalties, but I think it's always seen in light of whether the company where the breach has occurred or leakage has occurred, whether it's been careless. And that's coming back to what was said earlier. It's even more important to have a proper set of documentation that shows that you tried to comply with the act in spirit. You should be able to demonstrate to the regulators if asked, be conservative in the beginning if required when you're complying with the act, if necessary. I think those go a long way in terms of avoiding or minimizing penalty. There will be always risk events, as we call them, outside your control. But as long as you have taken the appropriate approach and tried to do things as they are envisioned in the act, I think the penalty aspect you shouldn't really be worried about. That's our hope, at least, to be honest. I can't
Great.
guarantee what penalty will come in.
No, absolutely. Thank you so much. What I definitely want to say is that I think at the end of the day, good faith is what it's all about. Entities have to exhibit good faith to show that
Absolutely.
they took reasonable and due diligence. Care
That's
was
a good way
taken,
to
and I
put
think
it.
that should
Good faith
solve.
is exactly.
Good faith is absolutely at most at all points in time. I think, first of all, thank you so much. This is the time that we have today. So thank you so much for being with us today, both Sajay and Yogesh. We have received a few more questions and we will get back to the respective audience members directly. But for any further questions that anybody has, they can write to consulting@prudentbrokers.com. I think the takeaway for me at least is one, the 7 principles of data privacy, and second, don't play whack-a-mole with privacy. So moving on, I'm handing this over to Justin. Thank you so much. Have a good day, everyone. Justin, closing remarks, please.
Sure thing. All right. That was fantastic. I would like to thank our panelists, Yogesh Jinde, Sajay Singh, and our moderator, Jyoti Krishnan, for their fabulous insight. And we'd like to thank our audience. If you have questions from the Q&A that we could not answer today, as Jyoti said, Prudent will reply to you directly. Visit prudentbrokers.com for more information and see the videos page for past collaborations with RIMS. And as we said, the replay will be available through the on-demand events page feature of rims.org/webinars. Learn more about RIMS India through the community page of rims.org and follow our group on LinkedIn. We are India RIMS. Folks, also just wanted to let you know, Risk World 2024 will be held in sunny San Diego, California on May 5th through the 8th. So mark your calendars now. Get those passports and visas ready. Visit rims.org/events to learn more about the world's largest risk management event. Hear us weekly on RIMScast, our official podcast. That's rims.org/RIMScast. And finally, RIMS is global, and we would love for you to build your network with us. Visit rims.org/membership to apply for a RIMS membership. Thank you all, and stay safe.